Hello, everybody, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming partner and attorney Min Kim from our Edison, New Jersey office. Hi there, Min, and welcome.
Hey Ariana, good seeing you again.
Thank you so much for being here today. For today's topic, we're going to be talking all about alien registration requirements. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please comment them below or email us anytime at info@jig.com. So let's get right into it. Min, it's been quite the volatile period within immigration recently. I mean, just this month, we've had F1 students receive notices from ICE or their universities of their SEVIS records being terminated, only to now have ICE reinstate those same students into active status. And earlier this month, the alien registration requirement officially took effect. Frankly speaking, it's been hard to keep up with this news as it seems there's a new change in immigration law and policy almost every single day.
Yeah, I couldn't agree more, Ariana. In a way, I guess it's not all too surprising that this current administration is looking to make some waves and really cause some turbulence for foreign nationals and their employers in the immigration space. But the manner in which this administration has been seeking to implement those changes, with interim final rules, a rollout of a new G-325R form without proper testing and vetting of the form through focus groups and notice and comment, all of this has been surprising to say the least. I guess in the end, we collectively shouldn't be too surprised by these changes and the that comes from Washington. But even the U.S. federal government needs to adhere to fundamental precepts such as due process and the right against self-incrimination, which, unfortunately, this administration seems to have a hard time understanding.
I couldn't agree more. You mentioned Form G-325R. That's the new online form USCIS launched this month to enforce the alien registration requirement that went into effect, correct?
Yeah, that's right.
Okay, Min, so let's get right into it. Let's give our audience some background information on the form, this alien registration requirement that's affecting hundreds, if not thousands, of foreign nationals presently in the United States, and what employers and foreign workers should be on the lookout for. Can you give us some background on this?
Yeah, absolutely. So, under the Immigration and Nationality Act, generally speaking, all non-citizens ages 14 and older who were not fingerprinted or registered when applying for a U.S. visa and who remain in the U.S. for 30 days or longer, they must apply for registration and fingerprinting. And in addition, for kids under the age of 14, their parents and guardians are responsible for registering their children. And once the child reaches his or her 14th birthday, they must also apply for re-registration and fingerprinting within 30 days. So that is the alien registration requirement in a nutshell. And in essence, this alien registration requirement was USCIS's method in implementing an executive order signed by President Trump when he took office on January 20th. And the rule is rather clear in specifying that both civil and criminal penalties shall apply for individuals and even green card holders who are subject to the requirement in needing to register, but who happen to fail to do so within the specified time frame.
Civil and criminal penalties, what kind of penalties are we talking about here?
Well, monetary fines up to $5,000, prison time up to 6 months, and perhaps even removal proceedings being instituted against the offending party. Now, you have to keep in mind, those are the penalties that pertain to failing to register or failing to register one's child if the child is subject to this alien registration requirement. But there are also penalties associated with not carrying the registration proof on your person once you are registered.
But wait, Min, you just said, isn't the registration online? How is somebody supposed to carry proof of completing the registration form online?
After the form is completed, the G325R form, the form that I'm talking about, there's the option to print the form And it's rather critical for everyone who registered using the form to carry that printout. If you're stopped by ICE or some other federal official or even a local or state law enforcement officer, and you are asked about your immigration papers, that registration printout proving you completed the required G-325R form, that printout should suffice. Now, if you don't have that form on your person when you're stopped by law enforcement, then at that time you're exposing yourself to penalties.
The same penalties you mentioned before, 6 months jail time and fines that could reach $5,000.
Well, not quite to that extent, but penalties regardless. The thing to keep in mind is that the failure to register online with USCIS or failure to carry one's papers proving such registration, it must be willful on the part of the foreign national. So there's a mental component to all this. But frankly speaking, all this is so new and unprecedented on the part of the US government that, who knows how Homeland Security will seek to enforce such a requirement against foreign nationals whom they believe either failed to register on purpose or were caught not having the required proof of registration on them. Like now, there's a court case that is ongoing in the federal district court in Arizona, where the government is looking to charge an individual with a Class B misdemeanor for allegedly failing to comply with these rules. So all of this is, it's not just pomp and circumstance and a scare tactic on the part of DHS. The government is actually backing up its words with action.
That is very frightening, and it's sad to see that our country, which was founded by immigrants in the first place, devolving into a place where we are now enforcing a show me your papers type of regime.
It is, and I agree with you. It is pretty upsetting, but all is not lost though, as there are legal actions in the courts that are looking to reverse the far-reaching impact of this interim final rule. And because it is an interim final rule, the government is still reviewing comments to perhaps amend its scope. So I suppose in a way, all of this is really fluid at this point.
It certainly appears like it is, as it's really an evolving situation. But for now, what we do know is that this alien registration requirement is in fact in effect. So, what can you tell our audience about the rule and how to determine if they are subject to the rule? And if so, what must individuals do in order to comply?
Yeah, certainly. Let's first talk about who is excluded from the rule. US citizens are exempt from needing to register. There are also, in addition to citizens, other population groups who are exempt, but those are very specific and probably too few in number.
Okay, got it. So what about US permanent residents? I think you mentioned before that green card holders are not exempt from the need to register. Is that correct?
You're right. But even though US lawful permanent residents need to register, the fact that they have their green cards approved and in hand is evidence of them already being registered with the government. So essentially, they don't have to re-register again, since as part of their permanent residence application process, the required biometrics were taken in order to approve those applications.
Okay, I follow you. So green card holders are not exempt from registering, but the fact that they've completed that process and submitted their biometrics information, photos, fingerprints, etc., as part of their green card cases has in fact already registered them for this purpose.
Yes, that's right. And some other population groups who are considered already registered, according to Homeland Security, are one, individuals who have been paroled into the US already, even if that period of parole has expired. Two, persons who have been admitted to the US as non-immigrants and who are issued a Form I-94 admission record, even if that period of admission has already expired. Three, individuals already present in the US who are issued either an immigrant or non-immigrant visa from the consulate abroad before their last date of arrival. For foreign nationals who have received an EAD card in order to gain work authorization, as well as folks who have received a border crossing card. And five, and even non-citizens whom Homeland Security has placed into removal proceedings, they're considered already registered because as part of that proceeding, biometrics would presumably have already been taken by Homeland Security.
So essentially, it's about whether a non-citizen's biometrics have already been taken. That's what this alien registration requirement is really all about.
More or less, that's correct. In addition to the fact that Homeland Security wants to police the unaccounted for non-citizens who might have entered the U.S. without inspection and remain here undocumented, an argument can certainly be made that the agency also wants access to all non-citizens' identifying information so that searches can be made on databases maintained by the FBI and other law enforcement and national security agencies. Because if there is a hit on one of those databases for whatever reason, criminal or perhaps a perceived threat to national security, then enforcement actions can be started, whether that involves detaining that individual and prosecuting them, or perhaps even removing the person altogether from the United States.
And in a way, isn't that what's sort of going on with these earlier SCBIS terminations as well? I know things have changed back recently, and ICE has walked back from their earlier stance of terminating SCBIS records as a result of the mass number of lawsuits filed. But media outlets have reported that a large number of these SCBIS record terminations were the result of FBI database hits due to alleged criminal activity on the part of the F1 students, and which, after some investigation, has shown to be untrue in most occasions. It seems like there's some overlap between these two issues.
That's a fair point, Ariana, and certainly within reason. It's hard to say what the government's stated agenda is, and if that overarching one agenda item is the driving force behind this alien registration requirement and the huge spike in SEVIS record terminations that thousands of foreign students were stressing over. But it's certainly reasonable to think that there is some shared policy consideration between the two.
Okay, so we've established who is exempt from this alien registration requirement, primarily US citizens, and there's many other folks who are already registered, considered registered like US permanent residents, non-citizens who have received an I-94 after passing inspection, folks who've received their immigrant or non-immigrant visas from consulates abroad. So now let's talk about the individuals who need to register. What types of people are we talking about?
We're mostly talking about five distinct groups of people. One, Canadian visitors who might have entered the U.S. at land ports of entry, but who were not issued an I-94 emission record. Two, foreign nationals who might have entered the U.S. without inspection and thus were not admitted or paroled. Three, foreign nationals who might have entered the U.S. after inspection and parole, but who do not have one of the required forms of evidence to prove their registration. Four, younger non-citizens who entered the U.S. before the age of 14 and only turned 14 years of age while in the U.S. These young people are required to register within 30 days after their 14th birthday. And five, certain limited cases where when the acceptable form of alien registration is the result of an approved application only. So essentially, if that application were to be denied, then that individual no longer will have that acceptable piece of evidence to prove his or her registration.
Min, if I may, let's circle back to the example of the child who was under the age of 14 while in the US and now turns 14 while physically residing in the US. I think there's a lot of confusion there amongst non-citizens and their families. So you're saying that a foreign national child who might already have secured his or her H-4 visa stamp or L-2 visa stamp from the consulate and who has since flown to the US, been inspected by CBP at the port of entry, and sought and was granted admission in that visa category and received an I-94 record, even though most times those pieces of evidence are exactly what proves alien registration. In this instance, because the minor was younger than 14, that minor needs to register again when he or she turns 14. Do I have that correct?
Yes, that's correct. The registration does not need to happen until the child turns 14 while in the US. But when he or she does turn 14, the registration form should be completed within 30 days of the child turning 14. But that's what the rule requires.
What's so special about turning 14 years of age? I mean, I don't quite understand why USCIS has drawn a bright yellow line that separates children younger than 14 and those who have since turned 14 while living in the US.
Yeah, it's kind of amusing, but it really is about biometrics. If a child is less than 14, depending on the immigration benefit application we're talking about, there's a chance that fingerprints were not taken, so that identifying information is not captured on the part of the federal government to run those, FBI and other security related checks. Once that child turns 14 years of age, those fingerprints are often taken, and most times they're required. That's the reason why Homeland Security is now demanding that the younger minor child be required to register and thus be required to submit his or her fingerprints and other identifying information as part of the biometrics data collection when they turn 14 years of age while residing here in the US.
I guess I understand. It just seems rather arbitrary. Like in theory, let's say a child in L2 status turns 14 years old today and thus has 30 days now to register using Form G-325R. But instead of completing that form online, that child and his parents take a trip up north to Canada, visit Vancouver for a few days, and return all before this 30-day period expires. But since the child, who is now 14 years old, has received a new I-94 admission record, that new I-94 would in theory count as alien registration, wouldn't it?
Yeah, in theory it would. Thus, I suppose the child wouldn't need to complete the online form again because he would have proof of registering as a result of that trip to Canada and back. And since all that was done within the 30-day period required by the rule, it doesn't seem like there is anything to be concerned about in your hypo.
Exactly. And that's why, despite the reasons you shared about USCIS wanting biometrics of these minors, there's still some arbitrariness to it all. I'm not gonna belabor to the point. Let's talk about the actual form G325R. For those individuals who are indeed subject to registration, what should our audience be aware of in terms of this form? The form itself is quite lengthy and asks for a lot of information.
I absolutely agree. The first thing I suppose a concerned individual must do in order to complete the form is to create a My USCIS account if they don't have one already. Or, if they have to create and submit a registration form for their child, create an account for their minor child. But once that account is created, the option to complete Form G325R will be visible once they log in. There is no fee for the form, but I suppose people should know that as part of this registration process, biometrics needs to be taken, and a biometrics intake appointment will require a fee of around $30. So it's not entirely free of charge, as the fee will be collected later on once biometrics is taken. And as for the types of questions asked, there's a lot of overlap with Form I-485, in my opinion, which is the adjustment of status application for an individual who's been residing within the past 5 years here in the U.S. So some of the questions that require overlap are those residential history questions, their overall immigration history while in the U.S., questions pertaining to one's parents and marital history, as well as questions related to any arrests or run-ins with law enforcement and their overall criminal record. It's a long form, as you say, and it will definitely take time to go through it carefully to ensure there's no misstep made.
That's really useful information you've shared as so many non-immigrants attempt to wrestle with this new form and try to make sense of it. So you speak of certain missteps. What should our audience be on the lookout for in making sure to avoid those kinds of missteps?
Well, let's just start with the biggest issue, the elephant in the room of sorts. If an individual has a criminal history and or entered the U.S. unlawfully and remains undocumented in the U.S., then there's a real conversation that should be done with probably both a criminal and immigration counsel on whether you as a non-citizen should even complete the G325R form.
But wait, Min, they need to complete it, right? That's the entire point of all of this.
Yeah, that's right. The law as it stands right now, with both civil and criminal penalties lined up for non-compliance, it stipulates that one should definitely complete the online form. But the question remains, should they really? What's Homeland Security going to do once this information is shared by the individual to the government? Will ICE now come knocking on that individual's door to institute removal proceedings? Perhaps. To put it in other words, is this alien registration requirement, this Form G-325R, is the form even lawful on the part of USCIS? Because essentially, isn't Homeland Security forcing individuals to come out of the shadows and self-incriminate themselves? But that conduct, is in direct contradiction to the Fifth Amendment and the right not to self-incriminate. For an individual, US citizen, green card holder, someone here on a work visa, and even a person who entered the US without inspection and is undocumented, they have those rights. The Fifth Amendment instructs them that no one should be forced to release incriminating evidence against himself or herself, which can and will be used within a tribunal in some legal proceeding. Those Fifth Amendment rights apply to all individuals, but this G325R form is coercing those same people to do just what the Fifth Amendment shields them from doing.
So let me just plainly say it, it's unconstitutional.
Perhaps it's still to be determined, but trust me, this issue is long from being over and can potentially go all the way to the US Supreme Court.
That's so fascinating and definitely something for us to keep our ear to the ground.
Yeah, but with that said, I do still want to remind our audience that it's not at the Supreme Court right now. So not even at the appeal circuit court level. The requirement thus still stands, especially since just recently a district court judge refused to grant a preliminary injunction stopping the rule from taking effect here in the short term. So we'll see. We'll see how the end game turns out as litigation continues. But for now, the alien registration requirement is still here to stay. And if a non-citizen finds that he or she needs to comply with it, then they should do so promptly.
Absolutely. Any other pitfalls or issues to be mindful of?
Well, the address history that's required on the form G325R is really interesting. It really begs the question, what is the motivation for USCIS to collect the address history for an individual completing this form, this form G325R? I guess it can serve the address as an identifying marker and data point for the federal government. But if you approach this issue from a more cynical perspective, can this address history also potentially be weaponized against a foreign national? I believe it certainly can.
Uh-oh, weaponized, man. I'm almost afraid to ask.
It ties in with the requirement to complete Form AR-11, which is the change of address form to non-citizens. Even U.S. permanent residents, they must complete within 10 days of their move to a new address. And the failure to properly and timely report one's address change to USCIS using that Form AR-11, it can expose the individual to some rather severe penalties. We're talking about a misdemeanor charge, potentially monetary fines, and perhaps even prison time and deportation.
Wait, just for failing to update USCIS of moving from one residential location to another?
Yeah, it's built into the statute. Now, you have to keep in mind, in practice, is this provision really enforced to the maximum extent? No, historically it hasn't been. But we're also in unprecedented times right now, with the government trying to circumvent due process rules and with these, mass sevis terminations that you spoke of earlier, as well as allegedly violating people's Fifth Amendment rights with this G325R form. And speaking of the form, it expressly requires address history within the most within the most recent 5 years. And if an individual has moved often within those 5 years, then presumably an AR-11 form should have been completed for all those moves.
Okay, I follow you. But those situations where an individual has not completed the AR-11 change of address form within 10 days of their move, but now as part of the G-325 process, they are now disclosing the fact that they've moved to all of these other addresses within the past 5 years. Basically, they're admitting that they haven't complied with the law by notifying USCIS of all the times they've changed homes. It's like self-incrimination all over again.
Precisely. Now, all this is speculation on whether USCIS will actually use Form G-325R for that purpose and cross-check it against all AR-11 forms that were filed or which were not filed for that particular individual. But once again, this issue has historically not been a strong point of emphasis for the agency, as even Homeland Security recognizes that moving to a new home probably requires 100 more important things to handle in order to effectuate that move. But once again, it's a different time and climate nowadays, and recent events have shown that this administration is keen on using any and all issues to target perceived violations of both federal immigration law as well as state and local criminal law. I personally wouldn't put it past the government to weaponize these forms, the G325R form and the AR11 form. In this manner, even if they just attempt to use the non-completion of AR11 as an aggravating factor in a broader, larger case brought against a particular individual.
Excellent point. We really don't know what the administration is capable of, so it's sound advice to just prepare for any and all things. But considering this, then, what would you recommend? Our audience should know once more that this not official legal advice that you're offering, but broadly speaking, are you implying that such individuals do not complete the G325R form at all if they know that adverse information can be used against them, even something as innocuous as inconsistency in the address history?
No, I wouldn't go to that extent because at the end of the day, completing the form is still the way to go, in my opinion, until and unless a court holds otherwise. Now, this analysis can certainly change. It changes if you're talking about something more egregious and weighty, such as violent criminal record or making it publicly known that you're here unlawfully. And those cases should be treated in isolation and advice sought with a competent attorney on a case by case basis. But outside of those cases within those margins, attempting to complete the form as best you can in a timely manner, it is the preferred strategy.
Sounds good, man. And yes, great advice. And if you are watching this and need assistance with this, please reach out to us. We are coming close to the end of our time. So, any parting thoughts and final recommendations for our audience, man?
Perhaps one last one. I received my fair share of questions from clients on how to answer the question on the G325R that asks immigration status at last arrival. Apparently, for Canadians and children under the age of 14, the only available option under that question for the how did you arrive drop down menu is selecting quote unquote entered without inspection, or EWI for short. But answering in this way is incorrect and admits to certain wrongdoing on the part of the non-citizen that he or she never committed. And EWI, entry without inspection in immigration context, it's a grave offense which has long-standing consequences that will severely limit future immigration benefits that the individual might otherwise be qualified for. So removing the fact that answering in this way is just completely inaccurate, what should compel the non-citizen to avoid selecting EWI in the first place is knowing that such an admission on the part of the individual will result in future harm. So for now, it appears the question can be left blank and unanswered, which is probably the way to go. Or if a free text field is available, then to use that free space to clear the record and explain how in fact a person in fact did not enter without inspection, but that no other choice was available as part of that drop-down menu.
Good practical takeaway point and a reminder to our audience that just because the online G325R form is limited in the types of answers a person can choose, it doesn't mean that those answers alone must be chosen in completing the form, especially if choosing one answer over the other has such legal consequences. So that is all the time we have today. This brings us to the end of our conversation. Thank you everyone for tuning in. A special thank you to you, Min, for taking the time and sharing all of this wonderful insight with us. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. Let us know what topic you want to see next. And if you have any questions or suggestions or feedback, please email us anytime at info@chubb.com. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you again, everybody. Thank you so much, Min.
Thank you, Ariana.